Welcome to the daily current affairs of CivicCentre IAS, where we try to discuss the important articles from the Hindu, the Indian Express and the PIB from the UPSC CSC prelims perspective. Displayed are the list of topics which we are going to discuss in today's video. The first article of the day says that the Kerala State Human Rights Commission has raised concerns over the alleged right violations in the Malayalam film industry, flagged by K. Hema Committee report. In this context, let us talk about State Human Rights Commission. See, the Protection of Human Rights Act of 1993 provides for the creation of not only National Human Rights Commission, but also a State Human Rights Commission at the state level. So, a State Human Rights Commission can inquire into the violation of human rights only in respect of the subjects mentioned in the state list and the concurrent list of the 7th schedule of the Indian Constitution. Know that the State Commission shall consist of a chairperson and 4 members. If we have to look at the qualification of the chairperson, see, a person who has been the Chief Justice or the Judge of a High Court is qualified to become the chairperson of this commission. Now, if we have to look at the appointment, a chairperson and other members shall be appointed by the governor after obtaining recommendation of a committee consisting of the Chief Minister of the state, the Speaker of the Legislative Assembly of that state, the Minister in charge of the Department of Home in that state, and lastly the Leader of Opposition in the Legislative Assembly. Now, if we have to talk about the term of the members of the State Human Rights Commission, so the chairperson and the members of the SHRC hold the office for a term of 3 years or until they attain the age of 70 years, whichever is earlier. Further, the chairperson and other members are eligible for reappointment in the State Human Rights Commission. Further, after their tenure, the chairperson and the other members are not eligible for further employment under the central or state government. Notably, the chairperson or any other member of the commission shall be removed from his office by the order of the President on similar grounds as that of the chairperson and the members of the National Human Rights Commission. Now, let us look at the functions of the State Human Rights Commission. So, having the protection of the human rights as the major goal, the State Human Rights Commission has to perform various functions and responsibilities in order to fulfill its main aim. Firstly, to look into the violation of the human rights in the given state and especially prevent it from happening in the case of a public servant. Secondly, to arbitrate in case of pending legal proceedings, including the claim of human rights violations at any given time in the state. Thirdly, to assess the living conditions of prisoners and people who have been spending time in other detention centers. Then, to advocate more research and development on the subject of human rights. Next, to evaluate the conditions that hamper the people's lives and rob them of their basic human rights and recommend solutions for the same. Lastly, to raise a general awareness of the people with respect to the human rights and make them aware of various ways in which they can protect their rights from getting violated. So, these are the functions of the State Human Rights Commission. The second article of the day says that the Supreme Court held in a judgment on Friday that not all insults and intimidatory comments aimed at scheduled caste or scheduled tribe person would be an offence under the Scheduled Castes and Tribes Prevention of Atrocities Act of 1989. In this context, let us talk about Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989. See, it is an act to prevent the commission of offences of atrocities against the members of the scheduled castes and the scheduled tribes by the persons other than SCs and STs. So, it provides punishment for offences of atrocities committed against SCs and STs. Notably, the Act is implemented by the respective state governments and the Union Territory administrations, which are provided due to central assistance under the centrally sponsored scheme for effective implementation of the provisions of the Act. Now, what are the offences under it? Firstly, this Act does not apply to crimes committed between the scheduled castes and scheduled tribes or between the scheduled castes and scheduled tribes. Further, there are 37 offences included in the Act that involve patterns of behavior, inflicting criminal offences and breaking the self-respect and esteem of the SCs and STs communities. Significantly, among these are the denial of economic, democratic and social rights, as well as the exploitation and of the abuse of the legal system. Now, how is the investigation conducted under it? See, an investigation of offence committed under the Act cannot be investigated by an officer not below the rank of Deputy Superintendent of Police. Notably, the investigation should be completed within 30 days and the report should be sent directly to the Director of the State Police. Now, if we have to look at the provisions with respect to the punishment, firstly, the minimum punishment in most cases is 6 months of imprisonment, while the maximum is 5 years of sentence and with fine. Additionally, in some cases, the minimum is enhanced to 1 year, while the maximum goes up to life imprisonment or even death sentence. Significantly, according to the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Rules of 1995, the district magistrate or the subdivisional magistrate or any other executive magistrate shall make arrangements for providing immediate relief in cash or in kind or both to the victims of atrocity, their family members and dependents. The next article says that in the view of protests over alleged sexual assault on 2 4-year-old girls at a school in Badlapur near Mumbai last week, the Union Education Ministry has directed all states and union territories to implement its guidelines to ensure safety and security of children in schools. Further, the ministry has also asked them to inform the status of notification of the guidelines that it had issued in 2021 in accordance with the Protection of Children Against Sexual Offences POCSO Act. In this context, let us talk about POCSO Act. See, the POCSO Act, which stands for the Protection of Children from Sexual Offences Act of 2012, came into effect on 14th November 2012, which was enacted in consequence to the India's ratification of a UN Convention on the Rights of the Child in the year 1992. Significantly, it was intended to protect children from sexual assault, sexual harassment, and pornographic violations, as well as to establish special courts for such trials. Know that the Act defines a child as any person below the age of 18 years. Notably, it is the first comprehensive law in the country dealing specifically with the sexual abuse of children and is administered by the Ministry of Women and Child Development. Now, moving on to look at its key provisions. Firstly, the Act defines a child as any person under the age of 18, which makes it a gender-neutral legislation. Then, any person in charge of an institution, excluding children obviously, who fails to report the commission of a sexual offence involving a subordinate faces punishment. Further, a victim may report an offence at any time, even years after the abuse has occurred. Lastly, the Act forbids the disclosure of victim's identity in any form of media unless authorized by special courts established by the Act. The next article says that marking the enactment of the day of Mahatma Gandhi National Rural Employment Guarantee Act, Congress President Mallikarjun Kharge on Friday criticized the centre for its handling of the program, alleging that the present state of the scheme is a living monument of Prime Minister Shri Narendra Modi's betrayal of rural India. In this context, let us talk about MGNREGA. See, the MGNREGA is one of the largest work guarantee programs in the world, launched in the year 2005 by the Ministry of Rural Development. Know that the primary objective of the scheme is to guarantee 100 days of employment in every financial year to adult members of any rural household willing to do public work related unskilled manual work. Notably, Panchayat Raj institutions will implement this program. You have to know that the person days under MGNREGA defined as the total amount of work days by a person registered under the scheme in a financial year. Further, there are two primary objectives of MGNREGA. First one is to enhance the livelihood security of the rural poor by creating wage employment opportunities. Then to develop a rural asset base to boost productive employment, augment household income and sustain economical well-being. Now, if we have to look at the features of the MGNREGA, firstly, the Act grants a legal right to employment for adult members of rural households, with at least 1/3 of the beneficiaries being women. Secondly, if the work is not assigned within 50 days, the candidate or the applicant is entitled to receive an unemployment allowance. Further, this allowance is 1/4 of the minimum age for the first 30 days and a half for the following period. Know that the Gram Sabhas recommend and oversee at least 50% of the projects. Significantly, cost sharing is done between the central government and the states for wages, materials, and administrative expenses. The next article says that the space sector contributed rupees 20,000 crore to India's GDP over the last decade. In this context, let us talk about the space economy in India. See, the India space sector has directly contributed about $24 billion, which amounts to 20,000 crore rupees to India's gross domestic product over the last decade. Further, it has directly supported 96,000 jobs in the public and private sectors. Notably, for every dollar produced by the space sector, there was a multiplier effect of $2.54 to the Indian economy, and India's space force was 2.5 times more productive than the country's broader industrial workforce. Additionally, India's space sector has benefited from decades of consistent investment, with $13 billion invested in the last decade, which is the 8th largest space economy in terms of funding in the world. Also, the satellite communications contributed to 54% to the space economy, followed by navigation amounts to 26% and launches amounting to 11%. Now, if you have to talk about the FDI in space sector, so the government opened the space sector to 100% foreign direct investment. See, earlier, FDI was only permitted through the government approval route. But satellite related activities in the space segment can get foreign direct investment between 49 to 100%, as the Union Cabinet approved an amendment in FTA policy. Notably, now the satellite subsector has been divided into 3 different activities with defined limits for FDI in each such sector. The first segment, it is up to 74% under the automatic route. In this, satellites manufacturing and operations, satellite data products, and ground segment and user segment, but beyond 74%, these activities are under the government route. Secondly, up to 49% under the automatic route, under which the launch vehicles and associated systems or subsystems, creation of spaceports for launching and receiving spacecraft. But again, beyond 45%, these activities are under the government route. Next, up to 100% under the automatic route. Under this, manufacturing of the components and systems or subsystems for satellites, ground segment and user segment. Significantly, the ease in the FDI policy on the space sector by prescribing liberalized FDI thresholds for various subsectors or activities is in line with the vision and strategy under the Indian Space Policy of 2023. The next article says that the reports of the Comptroller and Auditor General are subject to scrutiny by Parliament, and the government can always offer its views on the said report. This was said by the Supreme Court on Friday, while setting aside a Delhi court order framing charges against Karnataka-based firm accused of facilitating illegal sale of coal rejects. In this context, we shall talk about Comptroller and Auditor General, in short called as CAG. See, CAG is an independent authority under the Constitution of India. Know that he is the head of the Indian Audit and Accounts Department and chief guardian of the public purse. Significantly, it is the institution through which accountability of the government and other public authorities to the parliament and state legislatures, and through them to the people, is ensured. At present, Sri Girish Chandra Murmu is the incumbent CAG of India. Now, if we have to look at the duties and powers of the CAG, see, the Constitution under Article 149 authorizes the Parliament to prescribe the duties and powers of the CAG in relation to the accounts of the Union and the states and of any other authority or body. Firstly, he audits the accounts related to all expenditures from the Consolidated Fund of India, the Consolidated Fund of each state, and the Consolidated Fund of each Union Territory having a Legislative Assembly. Secondly, he audits all expenditures from the Contingency Fund of India and the Public Account of India, as well as the Contingency Fund of each state and the Public Account of each state. Thirdly, he audits all trading, manufacturing, profit and loss amounts, balance sheets, and other subsidiary accounts kept by any department of the central government and the state governments. Next, he audits the receipts and expenditures of the center and each state to satisfy himself that the rules and procedures on that behalf are designed to secure an effective check on the assessment, collection, and proper allocation of revenue. Then, he audits all transactions of the central and the state governments related to the debt, sinking funds, deposits, advances, suspense accounts, and remittances. Further, he also audits receipts, stock accounts, and others with the approval of the President or when required by the President. Next, he audits the accounts of any other authority when requested by the president or governor. For example, the audit of the local bodies. Also, he advises the president with regard to the prescription of the form in which the accounts of the center and the states shall be kept. Further, he submits his audit reports relating to the accounts of the center to the president, who shall in turn place them both before the houses of the parliament. Lastly, he submits his audit reports relating to the accounts of his state to the governor, who shall in turn place them before the state legislature. Now, how is the CAG in India different from the CAG in Britain? Firstly, CAG of India is only performing the role of Auditor General and not of a Comptroller. But in Britain, it has the power of both Comptroller as well as the Auditor General. Then in India, the CAG audits the accounts after the expenditure is committed, that is ex post facto. But in the UK, no money can be withdrawn from the public exchequer without the approval of the CAG. Lastly, in India, CAG is not a member of the Parliament, while in Britain, CAG is a member of the House of the Commons. The next article says that the designs of the India's next mission to the moon, Chandrayaan 4, which will bring rock and soil samples back to Earth, has been finalized and will most likely happen in 2027, according to the ISRO chairman S. Somnath, on the occasion of the National Space Day. In this context, let us talk about Chandrayaan 4. See, Chandrayaan 4, which was slated for the launch around 2028, is a groundbreaking lunar sample return mission. Significantly, this mission aims to collect samples from the moon's surface and bring them back to Earth for scientific analysis. Further, the mission will involve a complex two-phase launch strategy utilizing multiple spacecraft modules. Notably, Chandrayaan 4 would involve a docking of space modules twice during the mission, when the modules fly from back to the moon to unite with the main spacecraft, and when the samples are transferred to the re-entry vehicle. Interestingly, ISRO has never docked a spacecraft earlier. Know that this capability will be demonstrated for the first time later this year with the SpaceX mission. Now, what is docking exactly? See, docking is a process where two spacecrafts moving at extremely high speeds are aligned in a precise orbit and joined together. Further, the Chandrayaan 4 spacecraft will have 5 separate modules in comparison to Chandrayaan 3 spacecraft, which made a historic landing near the south pole of the moon, had only 3 modules: the propulsion module, a lander and a rover. If we look at the constituents of the mission, firstly, lander module, which will touch down on the moon and then, using the robot arm, collect samples from the moon. After that, the samples will move to the ascender module. After that, what we call as the ascender module will go up from the lunar surface and will reach the lunar orbit to dock with the transfer module. Then the transfer module will have the lunar samples brought from the ascender module and will transfer these samples to the re-entry module at the lunar orbit. And the re-entry module, which is designed to withstand Earth's atmospheric pressure. Further, this module will ensure that the collected lunar samples will remain safe for landing on the Earth. The next article says that US has emerged as India's top trading partner during the months of Jan to June this year, while country recorded its highest trade deficit of $41.6 billion with China during the period. This was according to the think tank GTRI. In this context, let us talk about the trade deficit and then about the balance of trade of India. See, a trade deficit occurs when a country imports more goods and services than it exports. This means that the country is buying more from other countries than it is selling to them, resulting in a negative balance of trade. Further, trade deficits can be damaging, but they also bring welcome economic benefits. Notably, trade deficits allow countries to consume more than they produce more. So this can help to increase the economic activity and boost the living standards of the people. Now, talking about India's case during Jan to June 2024. See, during the Jan to June 2024, the US emerged as India's top trading partner, while India recorded its highest trade deficit of $41.6 billion with China, according to the Global Trade Research Institute GTRI. Further, India's merchandise exports grew by 5.41% to $230.51 billion in the first half of 2024. Notably, the exports to the US increased by 10.5% to $41.6 billion, making India's largest export partner. Then the UAE also saw a significant rise in exports, growing from 24.9% to $19.7 billion. Significantly, China has remained the largest import supplier to India, with imports rising to $50.1 billion, resulting in trade deficit of $41.6 billion. Know that China was India's top trading partner in the year 2024. The US overtook China as India's largest trading partner from Jan to June 2024, with the total trade between India and the US increasing by 5.3% to $62.5 billion. Lastly, the total trade with China also grew by 7.7% to $58.6 billion. The next article says that the Prime Minister Shri Narendra Modi presented 4 BHISHM cubes, which stands for Bharat Health Initiative for Sayog Hita and Maitri, to the government of Ukraine. Further, the Ukrainian president expressed gratitude to Prime Minister for his humanitarian assistance. In this context, let us talk about BHISHM cubes. See, these BHISHM cubes are designed to aid in the rapid treatment of the injured, potentially saving many lives. Further, each cube is equipped with medicines and tools which are necessary for the first-line care across various medical emergencies. Also, it includes surgical equipment sufficient to support a basic operation room capable of handling 10 to 15 surgeries daily. Additionally, each cube can manage around 200 emergency cases such as trauma, bleeding, burns, and fractures. Know that the cube is also capable of generating its own power and oxygen in limited quantities. Lastly, to ensure the effective use, a team of Indian experts has been sent to Ukraine to provide initial training on the operating of the cube. The last article of the day says that with an aim of reaching out to the particularly vulnerable tribal groups, habitations and PVTG families in 194 districts across the country, the Union Ministry of Tribal Affairs is running a nationwide information, education and communication campaign and beneficiary saturation camps for Pradhan Mantri Janjati Adivasi Nyaya Maha Abhiyan, in short called PM-JANMAN, from 23rd August 2024 till 10th September 2024. In this context, let us talk about PM-JANMAN scheme and then about PVTGs. See, the PM-JANMAN is a mission aimed at supporting 75 particularly vulnerable tribal groups across 18 states and 1 UT. Significantly, the Ministry of Tribal Affairs, in collaboration with the state governments, is conducting a data collection exercise using the PM Gati Shakti mobile application to assess PVTG population figures and identify infrastructure gaps. Know that the number of PVTG beneficiaries covered under the mission will depend on eligibility criteria and specific guidelines. Notably, the mission has a total budget of 24,104 crore rupees, with 15,336 crore rupees contributed by the central government and 8,768 crore rupees by the state governments. However, the release of the funds is contingent upon the adherence to the scheme guidelines, submission of proposals by the state governments, and compliance with the general financial rules. More importantly, PM-JANMAN aims to provide PVTG households with essential services, including safe housing, clean drinking water, better access to education, healthcare, nutrition, low road and telecom connectivity, electrification, and sustainable livelihood opportunities within 3 years. Significantly, the mission focuses on 11 critical interventions implemented by 9 different ministries. Now, if we have to talk about the particularly vulnerable tribal groups, in short called the PVTGs, see, PVTGs are the most vulnerable among tribal communities, characterized by specific features such as reliance on hunting and gathering, pre-agricultural technology, zero or negative population growth, and extremely low literacy levels. Now, what is the need for the identification? See, PVTGs are more vulnerable compared to other tribal groups and often receive less of the tribal development funds due to dominance of more developed tribal communities. So, recognizing this, the government of India began identifying the most vulnerable tribal groups as a separate category in the year 1975, initially listing 52 groups. Notably, this number was increased to 75 in the year 1993, and out of the total of 705 scheduled tribes, as per the 2011 census, across 17 states and 1 UT. Further, the Government of India identifies PVTGs based on the following criteria. Firstly, pre-agricultural level of technology. Secondly, low literacy levels. Thirdly, economic backwardness. And lastly, declining or stagnation population. Remember that using this criteria only 75 PUTGs have been identified across the country. So we have discussed 10 articles in total for today from the Hindu, the Indian Express and the PIB from the UPSC CSA prelims perspective. We'll be back again tomorrow with another video. Thank you.